or someone you love is currently navigating the US immigration system, the ground under your feet just shifted again. Right now, green card applicants across the country are facing a wave of mounting denials. The Trump administration has rolled out a fresh series of regulatory reforms, stripping away key protections and leaving thousands of families in legal limbo. Today, we're breaking down what's changed, who's being hit the hardest, and why immigration lawyers are calling these subtle shifts absolutely devastating. To understand the stakes, let's quickly look at how the system is supposed to work. A green card is the primary pathway to permanent residency in the US, offering unrestricted work authorization, freedom of travel, and access to key benefits. Most people get there through two main routes: employer sponsorship or family sponsorship, most commonly marrying a US citizen. Normally, if you're already in the US on a valid visa, you file for an adjustment of status. You sit down for an interview, answer routine questions about your life, and show your lease and photos, and often within weeks, you're approved. Not anymore. The policy memo introduced this summer urges immigration officers to treat applying from inside the US as an extraordinary measure, a matter of discretionary grace rather than standard practice. Instead, applicants are increasingly being pushed to return to their home countries to apply through consular processing. Why is that a problem? Because leaving the country can trigger mandatory re-entry bans, especially with travel restrictions tightened on nearly 40 countries. And then came the knockout blow in July. The Department of Homeland Security official rescinded a Biden-era public child protection. Under the old rule, officers could only flag applicants if they relied on direct cash assistance. Under the new rule taking effect September 18th, using non-cash benefits like Medicaid, CHIP, or SNAP food assistance can be grounds for rejection. Critics warn this gives officers broad power to deny cases based on subjective criteria, or even personal bias. The results are already showing up in the data. USCIS denial rates have climbed steadily, from 8.6% back in 2016 to over 11% recently. So, who's taking the hit? Legal experts say officers are using these new discretionary powers to target specific groups, particularly students on F-1 visas, DACA recipients, and those on temporary protected status. Immigration attorney Alex Axelrad notes that while traditional spousal applications are still moving forward, any rush to marry due to visa deadlines is now immediately flagged as potential fraud. Advocates also warn of a massive chilling effect as legal immigrants drop out of essential healthcare and food programs to sheer fear. So what happens next? First, the legal fight is far from over. Multiple civil rights groups are already preparing lawsuits to block the public charge rule before it takes full effect, much like federal judges did back in 2019. Second, legal experts say the core advice for couples hasn't changed. Document everything, maintain your legal status, prove your marriage is genuine, and hire an experienced attorney to navigate the landmines. The rules of the game have changed, but the legal battles are just beginning. If you found this breakdown helpful, hit that like button, subscribe for daily news updates, and drop your thoughts in the comments below. Do these changes make the system fairer or just more broken?